Hello, greetings from Estonia. I'm Pirkko Liis, and as I also work as an employment law counsel, but in our Tallinn office. I will kick off this webinar with some insight into how legal regulation and remedies work in Estonia regarding mobbing-free work environment. So let's start with a short look at what the legal framework is. We can start with the first slide. Thank you. So as Andis mentioned, there is no legal definition for mobbing. It doesn't exist on the EU legislative level, neither does it exist actually on local levels. So from where then we can find what is mobbing and what the employers have to do, or what the employees can do, and what remedies they have, then we have to look at various laws that gives us actually bits and pieces, and when we put these together, we get the legislative background and framework of the obligations related to ensuring a mobbing-free work environment. The first and foremost legal act that regulates mobbing is Occupational Health and Safety Act. It's largely due to the fact that mobbing is recognized under this law as a psychosocial risk factor present at the workplace. So as we all know that mobbing can have long-lasting effects on people's health and lives and mental well-being. So this is something that may cause long-term work-related stress. So employers need to take this into account among all the other risk factors present in the workplace. So Occupational Health and Safety Act gives this general framework what the employer has to do when ensuring a safe workplace. Employment Contracts Act also obliges the employer to ensure a safe workplace and not discriminate. Employers are obliged to respect employees' privacy and monitor the performance of duties in a way that is not in violation with the fundamental rights of the employees. So this also gives some sort of general obligations for employers. How to create a safe working place. And mobbing, of course, may also take the form of discriminating activities. So we have a Gender Equality Act and Equal Treatment Act that prohibit discrimination respectively based on gender or based on such characteristics as nationality, race, color, religion, age, and so on. So this is basically the legal framework that we can use when we talk about employers' obligation with regard to ensure a mobbing-free work environment. So let's move on to the next slide and have a brief look at what these employers' obligations entail. So ensuring a safe and healthy workplace means going through all these usual processes that the employer has to go through when ensuring that the workplace is a good place to work, basically. I'm sure you all know that there is the obligation to do a risk assessment, prepare an action plan based on the risks identified, take some measures how to mitigate the risks and so on. And then quite often during the risk assessment period, these psychosocial risk factors are forgotten about, are taken rather lightly. But I want to stress that it's very important that these issues are taken into account, because when it happens that there is a mobbing case in your workplace, then it's very important that you have had a risk assessment of something like this happening. You have put a strategy in place how to react when something like this happens and how you actually prevent. So on this slide, as you can see, we are talking about preventive measures, and most of the measures that the law sets forth are preventive measures. So this risk assessment and action plan based on it will give you basically tools on how to prevent mobbing happening in your workplace in the first place. It has been also found that if the employers have good codes of conduct in place and have trained their employees on mobbing related issues, then it's also the mobbing doesn't happen so often and so on. And it's also important that once you have everything like that in place, the risk assessment, action plan and so on, you carry out systematic internal audits of whether your system actually works. Of course, you need to ensure that the workplace is free from discrimination, that there is no sexual harassment or gender-based harassment in the work environment, and that it doesn't also happen on these other characteristics like age, nationality, race, and so on. And when you envisage kind of measures how to monitor whether your employees are performing their duties or not, then all these measures have to be structured in a way that they are not interfering with employees' dignity or private life, or they cannot be too evasive. For example, you have to follow the principles set out in the GDPR that you cannot collect excessive data or request the employees to provide excessive data about their private life, or and even use that data not for the purpose but for some I don't know some making judgments or whatever that could create a discriminative or hostile workplace. And you cannot monitor performance in a way that you put constant control over employees, or you do it in a manner that the employees always feel like they are monitored and that cannot feel free, for example. So all these are kind of preventive measures that help employers to create a nice workplace and keep it like that. But let's have a look at the next slide. Here we have some reactive measures when already something has happened. So Agnieszka and Tatjana will look at the recommendations how to act in a more detailed way, but these are the items that in Estonian court practice and legal practice have proved to be useful. It's always the primary thing is that don't kind of ignore any complaints regarding mobbing, start immediately investigating, and the best way would be to engage outside consultants who are impartial and neutral, and always remember that there are two sides, so you have to talk to both sides, and you have to collect evidence. There is a shared burden of proof, so you have to be ready to prove also that you have done everything to prevent mobbing from happening. There might be a need to reorganize work and take also disciplinary measures towards those who have been engaged in mobbing. But when you do so, be mindful that you need to have good evidence and grounds to take these disciplinary measures. So you really have to investigate and see that you are not firing somebody over false accusations, for example. And it's important to reassess all the risk factors present in the workplace related to this mobbing, and maybe retrain employees and arrange also for some psychological help. On the next slide, we can have a look also that the employees also have to cooperate, and it's not only the employer who has the obligation. So employees basically need to refrain from such acts that influence other employees and prevent them from performing their duties. And also under the Occupational Health and Safety Act, there are obligations on employees that they have to cooperate in creating a safe environment. So it's not only the employer who has these obligations. So, and of course, if the employees do not follow these obligations, these are copied here from the law, then they may be held liable for breach of their duties. And on the next slide, we will see what are basically the consequences when something like that happens. So if employee feels that they have been subject to mobbing in workplace, and they have complained about it to the employer, but employer hasn't taken any measures, then they may terminate their employment contract, accuse the employer of being in breach with employer's duties to ensure a safe workplace, and in such case the employer has to pay a severance in the amount of the employee's 3 months average salary. And basically, to get rid of this, or if the employer is quite sure that they haven't done anything wrong, then the employer has to challenge the termination in court, and this is how most of these mobbing cases actually reach the court. And possible claims that the employees can have, in addition, they can also request that the damaging behavior is stopped, and they can also request damages. They can turn to Employment Disputes Committee or civil court. And employees can also, but also employers, but they do it less often. Employees can also turn to the Commissioner for Equal Opportunities. They can get counseling, but also receive a legal opinion on the situation and recommendations how to solve it. But the Commissioner doesn't have any official investigation powers, or they cannot impose penalties or damages. So this opinion they give can be used in a dispute as a good argument. It's not considered as evidence that mobbing has happened. The court would decide on that, but it gives a supportive argument for the employee. The Employment Inspectorate basically can also supervise whether the companies have in place this risk assessment that would also include these psychosocial risk factors and so on. But as far as I understand from publicly available information, there haven't been any cases where Employment Inspectorate has actually sanctioned anybody for failing to include these in their risk assessment. So on the next slide, I have added some links to additional reading. Most of these are in Estonian and published by Estonian authorities, but there is also in the European level an e-guide on managing stress and psychosocial risks that is available in English and somehow also in Lithuanian. So if you are interested and have questions or want to know more about what to do when mobbing happens, or how to prevent mobbing, or how to assess the risks, then you can have a look and read further when accessing these links. So I think it's all from my side. I understand we have rather brief time. The topic is very interesting, and we could all talk hours about it. But send us our questions, and in the end we try to answer. Thank you. So let's proceed now to look at some of the mobbing cases in Estonia very quickly. If I can have the first slide. There are some cases, of course, that reach Employment Disputes Committee and that reach courts, but unfortunately these are not very numerous. Mostly this could be due to the fact that not all employees are knowledgeable of their rights, or they don't even recognize what mobbing is, and the same goes for employers. There was like a survey a few years ago that established that maybe only 4% of employers are aware of mobbing related issues. But still 10% of employees feel constantly mobbed at their workplace, and this is based on also on a very recent survey, and actually the survey stated that it was the same result 10 years ago, so there hasn't been any real improvements, but hopefully more of these cases reach the court. In Estonia, the employment disputes committees and courts have had cases both establishing mobbing and not establishing mobbing. I will not go into very much details of all the cases, but maybe some more kind of important ones, that certain unpopular decisions by the employer are not regarded as mobbing. For example, if employer asks to provide an explanatory letter about something that the employee has done, it is not the entitlement of the employee to always receive praise, recognition, or acknowledgement from the employer. The employer decides whether or not to praise the employee or reward the employee. Rejecting employees' proposals is not regarded as mobbing. Such emotionally heated conversations that have been actually provoked by employee himself or herself are not usually mobbing if they are not kind of repeated. And all these inconvenient decisions where employees not always, for example, going to get vacation at a suitable time, or can request suitable working hours, and so on. And for example, in Q&A we have had several questions whether termination can be considered mobbing. We had a case where employee was prohibited to eat and exercise in an open plan office, and she felt that it was mobbing because it was her right to do it, and so the termination was mobbing. But actually it was found that maybe the behavior of the employee was not correct in this instance, and she was like doing this in a very suitable place. So on the next slide we will see what our courts and employment disputes committees have regarded as mobbing. The most importantly, Tallinn District Court has kind of defined what mobbing is, and it's very similar to how it's been dealt with in the courts in other Baltic countries. And then, for example, mobbing of others was found to be like a constant chattering in the office, and always interfering with the work of others. There was a waitress fired after she complained that she didn't like the chef's flirting, and the employer's explanation was that it's easier to find a new waitress than a chef. There was some public comments by a supervisor about eating habits of an overweight sales representatives, and a lot of cases are related to where mobbing is determined are related to how mid-level managers monitor employees' kind of rest and toilet breaks, that they stalk behind the toilet door, deduct toilet visits from working hours, and perform constant video surveillance of everything people do during their rest breaks. Then repeated remarks regarding employees' private life have found to be mobbing, and constant remarks that other people do not wish to work with a particular employee. And in one case, it was during the trial period that the new colleagues the colleagues were so unhappy about a new colleague joining that they constantly made derogatory remarks and spread rumors, joked at the expense of the new worker, and basically it was like textbook mobbing case. So these are some examples that have reached the Court for Employment Disputes Committee, and according to statistics, Employment Disputes Committee basically gets 10 to 15 phone calls a day about mobbing on their helpline, and there are like 20 cases per year perhaps that involve mobbing, but mostly these cases are settled by agreement, and this I see happening in my personal practice as well, that some reach Employment Disputes Committee, but usually these are settled by agreement, which is good for the employer, but perhaps not so good for developing really the practice, legal practice around mobbing. So that's the situation with cases in Estonia.